Handled, though, the question to you is in what provision do you put your marbles? I mean, in addition to 3583I, Mr. Unikowski would say back to you, look, there is no fugitive tolling provision in this statute of the kinds that the government wants. There is a tolling provision in the statute. It applies to prisoners. It does not apply in this situation. And there is, in addition, a fairly granular, detailed instructions about what to do with a person like the petitioner here. In other words, that there should be a revocation, there should be a new sentence of imprisonment with a term of supervised release attached to it. So the statute offers a solution for what to do with prisoners like Ms. Rico. So where are we supposed to look in the statute for your solution?
Right, so I think there are a couple of analytical questions baked into this case. And the first one is just, are you serving a term of supervised release when you're unsupervised? And if you agree with us on that, that is just about, the basic fundamental essence of supervised release, looking at the full range of statutes that Congress enacted here, 3601, 3603, 3624E, and saying, yes, Congress anticipated that when someone is sentenced to a term of supervised release, they will actually be supervised by a probation officer. If you agree with us that you have to actually be supervised to be discharging a term of supervised release, then you've already disagreed with petitioner's position. And then we just get to the secondary question of, okay, what do we do with these release conditions after abscondment? And I'm happy to talk about that and why I think that abscondment should not.
If I take your argument right, that suggests that the only statutory provision you're pointing to is the one that identifies the person who actually does the supervision. Is that correct?
I think 3601 imposes an obligation on a supervisee to be supervised, and 3603 imposes an obligation on the probation officer to supervise. I think that those work together. Yes.
It's pretty bare bones, yeah?
Respectfully, I disagree with that characterization, Justice Kagan. And I think I will acknowledge that there is not an explicit fugitive tolling provision in the Sentencing Reform Act or any of the amendments akin to the carceral tolling
Nor
provision.
Is there a lot of detail about what the supervision looks like. So to the extent that you're putting all your marbles in this idea of supervision, I mean, the statute basically says, go get supervised.
I mean, I think 18 U.S.C. 3603 actually puts some meat on the bones of what supervision should look like. I grant that that is oriented toward probation officers rather than the supervisee herself. But, I think that tells us what Congress thought supervision would look like in practice and what kinds of requirements for monitoring, reporting, assistance Congress was trying to bake into this system.
Thank you.
Yeah, just to get to the 3624E carceral tolling provision, I think as we pointed out in our brief, Congress had a very good reason for explicitly addressing that, and it's because there was a disagreement in the case law as to whether you would toll for terms of incarceration that arose during a period of supervision, but were based on conduct that predated the term of supervision, so they couldn't quite be tethered to a violation of supervision in the way that this court treated the interruption in Anderson versus Corral and Zerbst versus Kidwell. Congress resolved that judicial disagreement in favor of more tolling. I don't think that tells us much of anything about what they thought about fugitive tolling. Certainly, it doesn't foreclose the existence of fugitive tolling in